And please continue with your lunch. I will try to make my brief talk as simple as possible so that it will not interfere with your having a good lunch. And one of the most difficult tasks is to speak during a lunch. So I will make this as friendly as possible. Well, I was invited, I think, because 8 or 9 years ago, we won a case dealing with the South China Sea, or what we fondly call the West Philippine Sea. It's a smaller part of the South China Sea. I was then the Solicitor General of the Philippines, but then I moved on to, after we had filed the complaint, I moved on to become Justice of the Supreme Court, but I continued to help. So I was part of the team that drafted the complaint we filed before a special tribunal constituted under UNCLOS. And by that time we had the we won the arbitration. In 2016, I was already in the Supreme Court, but we will just tell you where we are now. And I'm very glad to be invited to this forum because I have been advocating that there be a second part to the complaint that we filed. The complaint that we filed in 2012 was called a landmark case. So I will explain today why there in my view, as a private citizen, why there is need for a second case. This is very propitious because actually the Secretary of Justice of the Philippines now advocates for the filing of a second case. And we are very lucky that Secretary of Justice came from the House of Representatives. That's Secretary Crispin Remulla was one of the stalwarts of the House of Representatives. But he I think almost immediately after President Marcos was elected, he was drafted to be a Secretary of Justice. Now, to give you a fuller background, last September, I retired from the Supreme Court in 2019. So, by way of explanation, I am totally speaking here as a private citizen. But in September of last year, Secretary Remulla, who is the present Secretary of Justice, called for me. And we talked about the possibility of filing a second case. And I will explain to you today what a possible second case is. But I said I'm very glad to have been invited to this forum because then my private advocacy now has gained some kind of traction with the Secretary of Justice having gone public about the second case. But again, I would like to caution that I did not talk with the Secretary about this case. These are all my private this is a completely private initiative, but I hope that with many friends here in the House of Representatives, that Secretary Remulla could be able to, in due time, convince President Marcos to go ahead with filing the second case. Next slide, please. So, very, very briefly, this is what we won in 2016. Very, very simply, we won, I would say, 4 big points. The tribunal unanimously held, number one, that China, and mind you, when I say China, the tribunal ruled that China as a country had violated the sovereign rights of the Philippines over its EEZ, or its exclusive economic zone. That's the first important holding. And we presented evidence for this. Unfortunately, when we filed the case in 2012, we took more than a year to prepare. In 2012, 2013, 2014, you have to have preliminary exchange of documents. So we got a hearing towards 2015, and we won the case in 2016. So that is what I'm stressing now to Secretary Remulla, that there's a case build-up phase, but we must hurry. We must hurry. Because it took us around 6 years from the time we filed in 2012 up to the time we won in 2016. Second, again, based on the evidence that we presented at that time, the tribunal held that the China had violated the Filipino fishermen's traditional fishing rights in Scarborough Shoal. Scarborough Shoal is contested, but the ruling is that Scarborough Shoal, the fisheries around Scarborough Shoal, have traditionally been fished by many countries, including China, Vietnam, and the Philippines. That's the second headline ruling. Third, our complaint was based on an international treaty called the UNCLOS, the United Nations Convention on the Law of the Seas, or UNCLOS, of which China and the Philippines are members. And so, the third important ruling is that China violated UNCLOS obligations not to have land reclamations. Because under UNCLOS, no country, however powerful or big, can just reclaim parts of the sea, which is what China did. And last, but very relevant to what's happening now, we presented evidence and the tribunal held in our favor. It ruled that China had committed many, many instances of violations of maritime safety by creating risk of collision. So I am refining into 4 general terms what we won in 2016. But the problem is the suit that we filed just asked for a declaration of our rights. Now, why did we ask merely for a declaration of our rights? Frankly, we were not sure of winning the case because it was the first time that a case was filed under UNCLOS and especially against China. Now, I can tell you that we consulted many figures in international law. And we were advised that our chances of even progressing the suit was merely 50-50. Meaning we had an even chance. We could have won or we could have lost on jurisdiction. Meaning there had been no case filed against a country as big as China. So we were warned by a professor in Yale. that our chances are 50-50. But we were also told that if we can hurdle the problem of jurisdiction, then our chances go up to 80%. Those among us who are lawyers know that the lawyers hate to give the chances of winning a case to a client. But the professor of Yale told us that. And so when we won the case, it was enough. That explains why we did not ask for damages. Now, the suit being prepared now by Secretary Remulla asked for damages over, I assume, the acts which were covered by the ruling up to 2016, and I suspect that he will add new facts. There are many here in our audience now from the Philippine Coast Guard. I think they are collating the facts to support a case for the violations after the 2016 ruling. Next slide, please. So, very, very briefly, what is the first count of a possible suit? Now, the ruling of the tribunal was that Mischief Reef, Ayungin Shoal, and the Reed Bank are declared parts of the Philippine EEZ, or the Philippine Economic Zone. Therefore, from that premise, the tribunal held that, number one, China interfered with Philippine petroleum exploration in the Reed Bank. That's very important. There was already a ruling that they interfered with our exploration at the Reed Bank. Number two, China prohibited fishing by Filipinos within our EEZ. Number three, China as a state, protected and failed to prevent Chinese fishermen from fishing within the Philippines EEZ, at Mischief Reef and Ayungin Shoal. And lastly, China constructed installations and artificial islands at Mischief Reef without Philippine authorization. This is very important. Mischief Reef is now controlled by China. But the tribunal held that by building an artificial military installation, by converting Mischief Reef from a reef into an artificial island, China violated its obligations under UNCLOS. So this means that just on Mischief Reef alone, the Philippines would have a very strong case for damages against China. That's on the first count. Next slide, please. The second count is that the Philippines has traditional fishing rights around Mischief Reef. Now, China was held together with Vietnam to have similar fishing rights over Scarborough Shoal. So when every time China prevents Filipino fishermen from fishing within the 12 nautical miles waters of Scarborough Shoal, that is a violation under the ruling. The third count, next slide please. Now this is very important. The tribunal also held that China's large-scale reclamations, you know what China would do? They will send giant trawlers which scoop up earth, and there will be tremendous damage to the environment. And the ruling was in seven features in the Sprat list, China did exactly this. So you can imagine how much damage you can claim, because we did not produce evidence of how much was the damage caused. So there is already a ruling by the tribunal that China, by its large-scale reclamation, did irreparable damage to the environment in 7 features, which includes Ayungin Shoal and our Mischief Reef. So you can imagine how much we can ask for damages. There is one expert who says it's 250 billion US dollars. But that I would leave that to the lawyers, because there's a way to compute the damage to the environment. Next slide, please. Now, this is very important because of current events. We have heard how the Chinese employ now lasers. There are many ways to interrupt our supply mission to Ayungin Shoal. The fourth count is that the tribunal held that the conduct of Chinese law enforcement vessels at Scarborough Shoal on 2 occasions, this was in April and May 2012, because at that time, China would, like today, they would send law enforcement vessels crisscross the path of the Philippine vessels, and that was held already to be illegal under maritime laws of which the Philippines and China are part. So while the ruling is only on specific incidents as of April and May 2012, the principle is the same. China cannot interfere. If China cannot crisscross our vessels and put our people, our Marines, our Coast Guard in harm's way, then you can project. If you file a new case, all of the incidents which happened after the ruling was handed down in 2016 can now easily be part of a case for damages. So I am just, in a very abbreviated manner, have presented to you just the 4 counts. But you can imagine how much damages you can ask. For example, how much damage has been done to Mischief Reef, which is undeniably under the control now of China. But we have under, we had a session this morning of the rules-based international order. What better proof of a rules-based international order than the UNCLOS? Because the UNCLOS is a multi-party treaty. And the beauty of filing a case under UNCLOS is that even if China does not participate, we can proceed to continue under UNCLOS. So, last slide, please. This is what Secretary Remulla said as recently as last month, January 24. He said, we are in discussion and the decision to come very soon. Of course, Secretary Remulla is like you, used to be a parliamentarian. He used to be a member of the Philippine House of Representatives, which is our host today. But I trust that he will, he has his own lawyers now. He will present this to the National Security Council. I think they have come here in full force, no? But General Anyo is not here, but they are all the all the luminaries of General Anyo are here. I think Secretary Remulla will very soon present to the National Security Council this suit. And Secretary Remulla is quoted also that the sins are really so obvious. We have also here the representatives of the Philippine Coast Guard, is General Gavan here. To this end, and in the end, the best way to attack. There are many ways of solving the problems, but this is one of the most novel ways. This is filing a second suit. So I have just given you a very, in the interest of time, and so that you don't get indigestion with I have presented to you. Now I feel very happy because I have gone around the Philippines, advocating this, but as I said, it kinds of it gets traction if it comes from the Secretary of Justice. So, thank you very much. Thank you.
Thank you, Mr. Justice. Do we have any questions? We have just a couple minutes. Yes, sir. Do we have a microphone right over here? The microphone here. Thank you.
Thank you very much, and thank you for an excellent overview. Franz Michael Melbourne, I'm the ambassador of Denmark. When talking to Chinese colleagues about the West Philippine Sea, they will claim that the Philippines has made an accord with the Philippines through former President Arroyo and also former President Duterte. Now, how do you think that these claims made from our Chinese colleagues will affect the ruling?
Well, under UNCLOS, China is a signatory to the UNCLOS, and so is the Philippines. Now, the reason we went to UNCLOS is that the UNCLOS as a treaty has very particular provisions. It says, in very rough language, it says that the fact that a country does not recognize a arbitration does not mean that the UNCLOS cannot take jurisdiction, provided that the claiming party can prove to the satisfaction of the arbitrators that indeed there is ground. And that's exactly what happened. China refused to participate. And the only effect was we had to, in terms of the filing fees, we had to pay the share of China. It was a substantial amount. But more than that, the UNCLOS requires that even if China does not participate, we have to prove our claims. So we had a difficult task because we had to prove our claims. So under UNCLOS, of course, China, what China did was to file their position. They filed it in The Hague. They filed it with they filed it with the Netherlands. But then they did not appear in the hearing. What they would do is to go publicly saying they have a position paper. But the bottom line is once the tribunal is convinced that it has jurisdiction, then it can go ahead. But it was very, very difficult because the tribunal was very solicitous about the the rights of China in terms of the litigation. So we had to make almost a double effort to really prove our case. But in the end, we won it. And as I said, we are all for a second case, especially for damages. Because under a rules-based treaty, what use do we have for the treaty if somebody can just violate it and worse, leave damage, for example, to the environment?
Thank you, Justice Jardeleza. We appreciate very much your remarks and very insightful.